Hello, Wisconsin. I am Hank Chambers, law professor at the University of Richmond. Been at this for a couple of decades, so it's good to see you. I'm sure we'll have a good discussion this afternoon. What we're going to have you all do, or what we're going to have our judges do, is introduce themselves and then have you all introduce yourselves and teacher. So my judging colleagues. We'll go with David first. Well, we'll go with Ben first. Go ahead, Ben.
Sure. Hi, I'm Ben Glickman. I'm an attorney with the California Attorney General's office. I'm also an alumnus of this program. I was on a nationals team way back in 1995. So congratulations on making it here. That's a great accomplishment.
And my name is David Hudson. I teach law at Belmont University in Nashville, Tennessee, and I'm a First Amendment Fellow for the Freedom Forum Institute.
And let's hear from you all.
Good afternoon or morning. We are juniors representing Unit 5 from Wauwatosa West High School as the state champions of Wisconsin. My name is Katie Castry.
I'm Ben Soboleski.
I'm Ella Schwantes.
I'm Marissa Retta.
And I am Layla Allen. We are here on behalf of our teaching assistants, mentors, and teacher, Mr. Chad Mateski.
Fabulous. Wauwatosa West always represents. So it's good to see you all. We will go with question 1 from Unit 5. So I'll read it and then we will hear your opening statement. A result of the decision in Wisconsin versus Yoder is that any parent guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with this result of the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights? We're ready for your opening.
Spiritual freedom is the root of political liberty. As the union between spiritual freedom and political liberty seems nearly inseparable, it is our duty to defend both. Thomas Paine's words embody the necessity of religious freedom as a means of maintaining liberty. However, Paine's notion of the two being inseparable only goes so far in the pursuit to defend both.
The courts have developed evolving standards to balance religious beliefs with other rights. Reynolds v. U.S. was one of the first cases to develop such a standard. The court ruled that polygamy is not protected by the First Amendment. Justice Waite, writing for the unanimous court, justified this in a manner that would prevent individuals from gaining greater power to govern themselves.
Nearly 80 years after the Reynolds decision, in 1962, the court departed from this precedent in Chipper v. Berner. The Supreme Court held that if states denied accommodations for religiously motivated conduct sufficiently burdening citizens' religious beliefs, then they must have a compelling interest.
In the 1990 Supreme Court case, Employment Division v. Smith, the court narrowed the standards formulated in Chipper v. Berner. Writing for the majority opinion, Justice Scalia referred back to Reynolds v. U.S., articulating that the First Amendment's free exercise clause safeguards religious beliefs. However, religious exercise can be limited by laws generally applied to all citizens.
In response to the conclusion in Employment Division v. Smith, Congress passed the Religious Freedom Restoration Act. The RFRA required courts to use strict scrutiny when examining laws relating to religious freedom. The court reinterpreted the compelling interest requirements used in balancing religious beliefs and other rights. The court's fluctuating opinion on religious exercise has affected decisions on other rights, such as marriage, bodily autonomy, and notably education.
Our panel agrees with the result in Wisconsin v. Yoder. However, some of our panel disagrees with how the court failed to take into account the religious practices or beliefs of the child. The court argued that only the parents are subject to prosecution for exercising their religious beliefs, and therefore the desire of the child is irrelevant. Those who don't align with the court agree with Justice Douglas in his partial dissent, where he recognizes the religious interests of the child as an individual.
In the case Zorach v. Clausen, the court recognized the right of students to freely practice their religious beliefs, and in Tinker v. Des Moines, students' voices were recognized by the courts. In the case of Wisconsin v. Yoder, the court should have relied on these precedents and acknowledged the rights of children as students.
There are no words in the U.S. Constitution that directly protect the right to an education. The court has protected the right to education through the 14th Amendment using the Equal Protection Clause. In 1982, with Playa v. Doe, the court struck down a Texas law that allowed the state to withhold funding from local school districts that educate undocumented immigrants.
all 50 states have a right to education listed in their constitution, with 37 including religious restrictions. In Article 10, Section 3 of the Wisconsin Constitution, it provides that students have a right to an equal opportunity for a sound-based education. The unanimous acknowledgement of a right to education at the state level demonstrates the necessity of preserving education for future generations.
This conflict between religion and other rights was recognized in Reynolds v. US when Justice Waite stated, "The question is raised whether religious belief can be accepted as a justification of an overt act made criminal by the law of the land." Since originally posed, this question has been inconsistently answered by the courts. The efforts of the courts, however, have been admirable, as deciding on a case-by-case basis is necessary when balancing rights of such importance. Thank you. This concludes our statement. We are now ready for your follow-up.
Thank you so much. I'm curious, how does Wisconsin guarantee the right to education?
Wisconsin guarantees the right to education in Article 10, Section 3, where it guarantees this right for students after the age of 4.
Wisconsin has upheld its right to education, as we can see with the Wauwatosa referendum that required schools to be redone as they were not meeting their standards.
How would equal protection apply to the right to an education if the right to an education existed in the U.S. Constitution?
The right to education can be applied through the 14th Amendment, and this can be using the incorporation doctrine established in Gitlow v. New York, where the Federal Bill of Rights is incorporated onto the state's Bill of Rights.
However, currently all 50 states acknowledge a right to education in their state constitutions, such as Kentucky that contains a right to education in their Section 183.
They did not protect the right to education through substantive due process, rather the Equal Protection Clause, and they recognize that undocumented immigrants are persons and they do have the right to an education, something no person should be denied of.
The right to education has been expanded through decisions such as Brown v. Board. As we can see at the national level, students cannot be discriminated against in the school.
Also, implementing the ratchet theory, states are able to evolve and expand these rights.
Had education been listed in the Constitution, we might say that the Equal Protection Clause might protect disabled students, as only 21 states protect the right to education for students with disabilities.
All right, let's shift gears just a bit. So one of the current topics in free exercise is the ability of states or local governments to impose COVID restrictions that impact worship services. Can a state enact a law that says, in groups over 100, we're going to limit capacity, even if that limits capacity at churches?
In the recent court case, Tandem v. Newsom, California ruled that you cannot restrict gatherings for religious purposes if we have exceptions for other reasons for the law. Currently, California had exceptions for different restaurants and stores that were available, and they ruled that they needed to provide a religious exception to this law as well.
Previously to Tuesday, Wisconsin had Governor Evers' order of no persons over 10 in a building. However, the Supreme Court struck this down because the state did not have enough compelling interest to limit the persons inside the building.
This notion was also seen in Cavalry Church v. Sisolak, where the state tried to implement these type of regulations. However, the court struck it down, saying that we must uphold the right of religion, and also can be seen sorry, excuse me.
That's okay. So do you agree with those decisions, or do you think the court is going too far, protecting free exercise at the expense of secular interest or protecting public health?
I agree with the decision in Tandem v. Newsom. If we are having exceptions for other businesses, then why wouldn't religion receive an exception as well? Religion is one of our most important First Amendment rights, and it is important that we continue to protect this right.
I agree with this notion, and this can be supported by the current Pew Research study that in Outlook magazine that identifies the study that found that less than 20% of Americans are practicing religion on a regular basis. This would implement a tyranny of the majority if we were not to protect religion today.
We can also see that these religious exemptions might extend to COVID vaccines as a reaction to the COVID-19 pandemic. Currently, for example, the state of Nebraska has validated religious exemptions as an excuse not to get vaccines. Although COVID vaccines is not classified under this because of under 21, Title 21 Food and Drug, it is under emergency use. However, in Nebraska statute 79217, they recognize religious exemptions. Well, not all states do. I believe that if they recognize religious exemptions, they should recognize philosophical exemptions as well.
So understandably, so Nebraska can't make you get a vaccination, but should Nebraska be able to stop you from going to school if you don't have a vaccination?
They should not be able to stop you to going to school if you don't have a vaccination. As seen in Colorado, Colorado Senate Bill 163, they allow non-medical exemptions students to still go to school. However, they mandate that schools must send out a form to parents in order to reach 95% immunity in order for herd immunity to kick into place.
It depends on if the school is public or private. Most public schools have religious exemptions. However, most private schools can do whatever they would like, as the First Amendment does not apply. And we can see this with the Tamarack Waldorf School in Milwaukee as one of the only schools where the over 11,000 unvaccinated children are allowed to be educated.
Personally, I believe to answer this question, we must rely on the decision of the health department. We can see that the Supreme Court also used this method in the Supreme Court case Jacobson v. Massachusetts, where they relied directly on the evidence collected by the Massachusetts Director of Health.
Should students be able to form religious clubs in their public schools?
This all depends on if it's within school hours. As seen in Engel v. Vitale, it was within school hours that these students were organizing a non-organization prayer, not with teachers involved. However, the Supreme Court struck this down by deciding that there's no place for government institutions or there's no place for religion in government institutions.
It depends on if the club is discriminating against people that are not in the club, as we can see with Christian Legal Society v. Martinez, when the court struck down the request to make a religious club a student-led organization.
It depends on whether or not the club could distract the students' learning and the school's mission, as seen in Tinker v. Des Moines. The clubs and students' rights extend as far as they don't distract from others' rights and education.
This can be extended outside of the school days and outside of the school itself, where we can see that the school cannot deny religious groups in the community to use their building, as seen in Westside Community School District v. Mergens.
This would violate the Establishment Clause, more specifically, as established in the Lemon Test, the third prong, that would be excessive entanglement.
I disagree. I do not believe that it would violate the Establishment Clause found in Lemon v. Kurtzman, as the second prong holds that it cannot endorse nor inhibit religion. And I do not believe that holding religious events after school hours for students who are able to form these meetings themselves would endorse or inhibit religion.
So would a course in the history of the Bible be a violation of the Establishment Clause?
In a private school, this would not be a violation of the Establishment Clause. The First Amendment rights do not apply to private schools, and therefore many of them are religious schools that do have Bible study classes as part of their curriculums.
Okay. Go ahead.
As found in Epperson v. Arkansas, teachers can teach the curriculum of evolution, and if students have religious exemptions, they can be exempt from these classes and can be fulfilled with other curriculums. I believe that this would apply to this situation where you are practicing religion, but if students feel like the school is compelling them to practice religion, then they would be exempt from that class and must go with a different curriculum.
A Bible course should not be studied in a public school. After the incorporation doctrine and the decision in Everson v. Board of Education, there was a high and impregnable wall that separated church and state. So there should absolutely not be a Bible study that should be practiced in a public school.
And we can
during
see
school hours.
Incorporation doctrine that this freedom of religion is extended to the states through the Supreme Court case Campbell v. Connecticut, where they involve the soliciting of Catholic religion, Jehovah's religion.
Sure. Let's shift gears just a little bit. Should a child's right to an education trump a parent's religious belief? In other words, when should the child be able to decide, I want to go to school, notwithstanding my family's religious beliefs?
The child should be able to just have a say in the court at the age of 16, as the death penalty would be applicable to these children.
However, as determined in Cruzan v. Director of Missouri, the parent's right trumps over the child's until the age of 18.
The student should have a voice in court, although it should not be absolute. During foster care court cases, at the age of 14, students have a voice. And although in Troxel v. Granville, the court recognized the right to parent, at the age of 14 is still age that students and minors should have a voice.
Students should have a voice at the age of 16. As ruled in Stanford v. Kentucky, students are subject to the death penalty. If students can have their life taken away from them, I believe that they should have a voice within their education.
What if the death penalty didn't apply to folks who are 16 and 17? Would that make a difference to your analysis?
Well, yeah. Yeah, it would make a difference to my analysis. If they cannot have a voice in their life, then why should they have a voice in their education? And in that sense, then their parents should supersede, as seen in Troxel v. Granville, where a parent's right to parent is more valid than a student's.
Thank you.
Great job. Let's recognize the students for their hard work and participation.
Very nice. Fellow judges, what do you think?
Okay, I'll go. I thought you guys did a nice job. You threw me a little bit. You jumped into the second sub question, and I was like, "Oh my God, they're going to miss that first main question." But then you you circled back, not surprisingly, at this stage that you didn't miss it, and you answered it. And I appreciated your discussion of the child's interest, and that's kind of what prompted my follow-up question, and referring to the partial dissent and Tinker and students' rights generally. It's obviously very relevant to you, and I think it's an important part of this complicated area of the law. Likewise, I thought you did a nice job talking about those evolving standards, from Reynolds to RFRA. And then on my follow-up question about COVID restrictions, you were ready to go with Tannen v. Newsom, which is, just a couple weeks old, and it's a case my office is handling. I'm not sure I necessarily agree with you that it was correctly decided, but that's okay. I think there's a real concern when you're comparing, Bible study meetings in someone's house to going to a restaurant or shopping at a grocery store. Those don't seem like the same thing. And I think there's an argument that they're being too solicitous of religion, and that at some point that's going to get to the point where they're endorsing religion, which would violate their own test in Lynch, right? But anyway, you're free to your own opinion on that. And I'm glad that you were aware of the case and were able to discuss it. That's all I really have. The only constructive thing I would give, and I know this is your last We the People round, so it doesn't much matter, but take a pause between speaking to allow the judges to get in there. Sometimes, we have more questions that we can get out, and that would allow you to show even more of your knowledge. So.
I also thought you did a great job. It's incredible participation. I like the quotations of Thomas Paine. You can never go wrong there. You mentioned the ratchet theory. That is an incredibly nuanced piece of constitutional analysis. I have not heard that anywhere else. I believe Ms. Allen mentioned that. It was really quite impressive. As far as constructive criticism, a couple little points. The court did overrule that Stanford v. Connecticut and Roper v. Simmons, so be careful on that. In Roper v. Simmons, the court held that no death penalty for those who commit murder under the age of 18. So that's one of those cases where the court has waffled back and forth in death penalty jurisprudence. And then in Abington School District versus Shemp, in Justice Clark's opinion, he does have a passage where he does talk about the possibility of teaching the Bible as literature and history. Now, granted, when a lot of school districts, as in my home state of Tennessee, in Chattanooga, Tennessee, they tried to do that, and it devolved into proselytizing, and so a lot of them have been invalidated. But I think it's good to at least recognize in Justice Clark's opinion, he does mention that possibility. Notwithstanding that, this was a superb job. The participation was incredible and outstanding, and you had so much information you wanted to impart. it's just, it was a pleasure having a conversation with you.
I agree with all those comments. Lots of good stuff to talk about. I do want you all sort of moving forward to sort of think about the distinction between the right to an education and the right, and what that means, because at least in theory, if you give a right, then you've got to give an equal right. So it kind of raises the interesting question about, should we have a right to education? I'd like to think we do, but the structure of what comes with that is an interesting one. And that was sort of where the mention of Brown versus Board, I thought was an interesting piece, because of course Brown wasn't so much about education itself versus an equal education in those circumstances. Judge Hudson just mentioned the issue with Roper versus Simmons. One of the reasons why I asked was because I don't know that the death penalty is the place where you necessarily need to go to find out whether a 16 or 17-year-old ought to be able to make a decision on their own. So I just sort of threw that out there. On the Bible class piece of the puzzle, same kind of thing. I just want y'all to sort of consider, as we protect people's religious freedom, what should they be able to put into the curriculum and not merely shield their children from? That's just one of those questions that I'd sort of love to hear even more from you guys on that, just not right now. But wonderful stuff. Good luck the rest of the day. You guys have done a fantastic job.
Thank you so much for your time.
Have a nice day.